Okay, this is Massage Bliss Inc. versus Farm Bureau General Insurance Company of Michigan, docket number 20-512CB. This is the time set for hearing on the defendant's motion for summary disposition. And before we start with argument, I'll take the appearances of counsel, please. Plaintiff can go first.
This is James Kelly appearing on behalf of Plaintiff Massage Bliss.
May it please the court, Your Honor, Amanda Fatma appearing on behalf of Defendant Farm Bureau General Insurance Company of Michigan.
Okay, and this is your motion, Ms. Fatma. You may go ahead.
Thank you, Your Honor. May it please the court, Your Honor, I think it's important to view this complaint and the claims presented therein within the proper frame, recognizing the complaint is devoid of allegations the insured property sustained any physical loss or damage, nor does the complaint affirmatively allege that any employee of the massage parlor, customer, or other visitor actually had COVID-19, nor are there allegations that an adjacent property sustained any physical loss or damage, which prompted some sort of civil authority order. Rather, we have a plaintiff attempting to artfully plead impairment to an economically viable use of the property as the equivalent to a physical loss or damage. And this argument has been rejected over and over again, not only by this honorable court and other Michigan courts, but on a national basis, noting the impairment of use or value cannot and does not act as a substitute for the policy's condition precedent of direct physical loss. These executive orders here in Michigan, which restricted the use of the property, were not prompted by any condition on the insured property because of physical damage to the structure, but rather were a pure economic loss, which at base is an intangible loss. Couch on Insurance, which has been noted as a readily available insurance treatise, notes that pure economic losses are intangible, while contrasting that with the fact that the requirement under a property insurance policy, including that for business income or extra expense coverage, be given physical, and that the ordinary definition is widely held to exclude all losses that are intangible or innate. So we have here a direct physical loss or damage, and the policy makes clear that physical loss caused by a peril insured against is a condition precedent to coverage. Whether it's under the loss of business income coverage or its coverage extension for civil authority, we start at the beginning with what perils are insured against. And the policy makes clear under that section it insures against direct physical loss only. And without delving into a detailed discussion of grammar and syntax, as Your Honor recognized in Gabrielli's, the term direct and physical both modify the term loss, and therefore there must be some physical, tangible damage to its structure. Direct physical loss of or damage to the property has to be something with a material existence, something that's tangible, something that alters the physical integrity of the property, which isn't present here. Thus, the requirement that something physical alter the structural integrity of the property is required. Judge Cleland's decision in Richard Kirsch DDS versus Aspen Am Insurance notably effectively slammed the door on the dicta in Turk that plaintiff attempts to exploit here, that the distinction between loss of should be used to cover the policy where a phrase loss of rather than loss to was found. Again, there must be some demonstrable harm to the premise itself rather than the forced closure of a premise as a result of reasons extraneous to the premises themselves or the adverse business consequences that flow. The plaintiff's complaint here seems to make crystal clear that the interruption of business was due to the very executive orders issued in response to COVID-19, including the ones issued by Governor Whitmer. The plaintiff acknowledges in its complaint that the government's response to COVID-19, including the issuance of those executive orders, including specifically Executive Order 2020-09, which the plaintiff cites specifically, is the basis of their claims. Those orders were issued to combat the spread of COVID-19. The plaintiff in its complaint paraphrases, in our opinion, far too liberally the language of the executive orders when it alleges that the executive orders recognize property damage caused by the novel coronavirus, which in turn was causing physical loss or damage to the plaintiff's property and nearby properties. To clarify, this executive order and the subsequent executive orders which extended it indicate specifically that they were issued to mitigate the spread of COVID-19, protect the Michigan public health, and provide essential protections to vulnerable Michiganders. Nothing is stated about COVID-19 causing property damage, generally, let alone to plaintiff's massage parlor or any nearby properties. Thus, plaintiffs paraphrasing that these executive orders somehow reference property damage specifically or somehow recognize that COVID-19 does in fact cause property damage goes too far. The plaintiff in its response asks this court to draw reasonable inferences because of its location, where its staff and customers reside, and the customers it serves, that there is somehow a physical spread of COVID-19 in the property that has and will continue to cause physical damages to solid surfaces and the ambient air. But in its complaint, the plaintiff again fails to allege COVID-19 was ever specifically traced to plaintiff's massage parlor. After we wade through the lengthy description of COVID-19's severity and the communicable nature of the disease, plaintiff poses nothing more than mere speculation and conjecture that at some time, unspecified, unnamed customers, employees, or other visitors were, quote, likely to have had the virus. Plaintiff is attempting to conflate the speculative presence of COVID-19 in the ether and within the Lansing area to direct damage to the property. These kinds of allegations have been addressed in other court decisions before, noting in declining to recognize the same that conclusory statements are not entitled to the presumption of truth from which an inference can or should be drawn. There is, unfortunately, a similar risk of COVID-19 in any public setting right now, regardless of artful pleadings as to its likelihood based on a prevalence within a certain community or a positive test rate. In Carmel Davis, which was Exhibit 4 to our reply, the court held that the likely presence of COVID-19 cannot be regarded as a physical change, as it does nothing to physically alter the insured property. And while recognizing that the virus may be transmitted through the air or may adhere to surfaces briefly, there's no indication it actually causes physical damage to property it may come in contact with. Further, more recently, the court in Pappy's Barbershop versus Farmers noted the presence of the virus itself or individuals who are inflicted with a virus at the plaintiff's property or in the surrounding place of business do not constitute a physical loss of or damage to the property. Further holding that even if COVID-19 was confirmed in the business income losses alleged, as here, were caused by precautionary measures taken by state and local officials to prevent the spread rather than any direct physical damage or loss of property. In similar vein, the court in Cork and Create noted when COVID-19 is present, it does not threaten innate structures covered by the property insurance policy. That its presence, even if actually confirmed, and again, that hasn't been confirmed at plaintiff's massage parlor, can be readily eliminated with disinfectant. Now, in Uncork, That case was pled as being linked directly to the insured premises. But the court held even where the actual presence of the virus would not be sufficient to trigger coverage. And here, distinct from Uncork and Pappy's previously, plaintiff merely alleges a, quote, likely presence of the virus within or around its massage parlor. Although the plaintiff draws these inferences or requests that the court draw these inferences to the likely presence at unspecified times by unnamed individuals, the court in Campbell Davis again recognized without more, these sort of blanket assertions are too generalized to support the conclusion that COVID-19 causes any physical damage. We must also take a holistic reading to the policy. In this context and with the assistance of surrounding terms, the loss of business income coverage is for a length of time as would be required to rebuild, repair, or replace as promptly as possible such part of the described premises as has been damaged or destroyed as a direct result of an peril insured against. Without some tangible physical damage, there would be no need to rebuild or repair or replace anything. To this point, plaintiff in its complaint has not alleged any part of the property must be repaired, rebuilt, or restored, and it appears that at such time the virus can be controlled or restrictions are lifted, it can resume ready operation. To read out a tangible physical damage element would be to render the later provisions related to what is essentially a period of restoration to permit repairs is completely superfluous. In its reply, plaintiff represents that there has been a trend nationally as to cases permitting policyholders to proceed. That is a misstatement. There is a trend, but the trend is overwhelmingly in favor of insurers. And even the cases which are cited in the response, holding or otherwise permitting policyholders to proceed, those courts note that subsequent decisions interpreting COVID-19 business interruption in the context of COVID-19 may very well change their current position. Some courts, as plaintiff notes, have found direct physical loss in the absence of demonstrable tangible damage. But the majority of the courts have rejected this view, including the Sixth Circuit in Universal, as well as the court in Texas in Diesel Brothers. Plaintiff suggests that cleaning is required to remove COVID-19 and therefore it's akin to smoke sufficient to give rise to direct physical loss. That is not the view of the overwhelming majority, but only of a few outliers that is subject to change. In August of 2020, the court in Mama Joe's versus Sparta Insurance Company pointed out that even though an item or structure may need to be cleaned, that's insufficient to find a loss, which is both direct and physical. This morning, our office received, as I believe did the court, supplemental briefing and authority as to the Eastern District's opinion in XL Salon versus West Bend. It's our position that that case is completely inopposite and should not be considered. Most notably, Judge Cox's decision did not contain any analysis whatsoever of direct physical loss or any of the existing case law, including Your Honor's prior decision in Gravidalis, nor the other decisions of Turek and Kirsch. So, in addition, that case is incredibly distinguishable in that the West Bend policy contained an additional coverage for communicable diseases. That's not present in this policy or even suggested in this policy. That fact alone makes a discussion of XL Salon's decision, in our view, entirely irrelevant. Similar to the reasons for which we believe there is no coverage under the business income extra expense portion of the policy, in that there is no direct physical loss. The plaintiff's claims for coverage under the extension due to civil authority, in our opinion, equally fail. The complaint does not plausibly allege direct physical loss to its own property, let alone an adjacent property. The text of the executive order cited by plaintiffs, including 2020-09, are far more constrained than the overly broad paraphrasing. Again, the executive orders restricting use of a property make clear they were issued out of precautionary measures to reduce the spread of COVID-19, to prevent an overwhelming impact on our health system, and to provide essential protection to Michigan residents. Nothing about that relates to any physical damage. Nothing about those executive orders specifically references or otherwise implies that COVID-19 causes physical damage. None of these orders cite the plaintiff's massage parlor specifically, or any property specifically surrounding the plaintiff's massage parlor. As the court in Henry's Louisiana Grill noted, an executive order which closed, in that case, dining rooms, merely recognized an existing threat and did not represent an external event that changed the insured's property. Also, the civil authority coverage, as stated in the policy, requires the physical damage to prompt the act of civil authority restricting access, not the other way around. The act of civil authority cannot be the cause of the alleged physical damage. A similar argument was presented and rejected in Turek, wherein the plaintiff alleged the civil authority caused the property damage by a resulting passive depreciation of its business personal property. The court declined to entertain such an argument. The civil authority orders here were issued in response to a devastating global pandemic and its emergence as a public health crisis here in Michigan, not in response to the actual or alleged presence of COVID-19 in response to the property at the insured premises or any adjacent property, let alone the result of any direct physical damage. Again, the complaint in respect to the civil authority coverage is devoid of any allegations of direct physical damage or direct physical loss to the massage parlor or any adjacent parlors or adjacent properties. A growing body of decisions at this point, approaching nearly 100, have decided in the insurer's favor. And in the context of civil authority coverage, the overwhelming trend has been that the plaintiff must prove a nexus between the physical damage to the property and the issuance of the civil authority order. That has not been done here. The civil authority orders upon which plaintiff's complaint rests do not mention property damage. We also note that the executive orders were issued on a statewide preventative basis versus a targeted basis particularized to any specific property as contemplated by the express language of the civil authority coverage. Aside from what we believe is the inability to meet the condition precedent sufficient to trigger coverage, and specifically that there has been direct physical loss of or damage to the insured property, this policy contains certain exclusions which bar coverage, most notably the acts or decisions exclusion, which excludes all losses that are solely a direct result of the acts or decisions, including those of a governmental body. Plaintiff's complaint cites the loss being the result of various governmental restrictions, most notably the executive orders issued by Governor Whitmer, and not because of any physical loss. The complaint also suggests that the business interruption losses even after being modified to allow a resumption of operation, continues to provide impact due to the need to accommodate staff or customers. Again, the nexus between the losses claimed and physical damage have not been met. The plaintiff states these losses are the result of restrictions, compliance with CDC guidance, and accommodating its staff and customers. But nothing is said about physical loss or damage. It's all about the acts or decisions of various government officials or other people, including its staff or customers. There's also an exclusion associated with loss of market, and that the executive orders here prevented Michigan residents from leaving their home except for engaging in essential functions such as urgent medical care or obtaining food or medication. While maybe providing a loss of market, that is the sole result or sole cause, if you will, Your Honor, of the plaintiff's claim of business interruption losses, either in whole or in part. For these reasons, Your Honor, we don't believe there's any coverage under the policy. The plaintiff's complaint has not alleged or pled that there is any physical loss or damage to the massage parlor, nor that the executive orders, which restricted perhaps use or access of the massage parlor, was a result of direct physical damage to any adjacent property. Additionally, there are several exclusions which bar coverage. I will be happy to answer any questions Your Honor may have.
I don't have any. I'll turn to Mr. Kelly.
Thank you, Your Honor. I do believe that the defendant is not reading the complaint in the most favorable light to the plaintiff, as the court is required to do in this case. Notably, the complaint alleged that there is a likely presence of COVID-19 within and around the insured property. That is sufficient for the court to accept that allegation as true. The complaint also alleges that both COVID-19 and the government shutdowns are the cause of the plaintiff's loss. That also must be accepted as true. Finally, Your Honor, I would note that the defendant is reading additional words into the policy, such as specifically the civil authority coverage, which does not refer to adjacent properties, does not refer to properties nearby on that block next door. It refers to properties other than the insured. So it is not a requirement under this policy that COVID-19 be physically present within Massage Bliss, which is a massage spa. I would like to just note all of those things at the outset, and that the court must accept those facts as true, and those provide a framework for this court's decision and analysis in this case. The defendant's position is that business income coverage, for business income coverage to apply, the property must be changed by a physical existence in a way that alters a previously satisfactory structure into a state that is no longer satisfactory and which requires repairs. They cite Universal as their authority for that position. Your Honor, COVID-19 is a virus that has a physical existence. It alters the surface of property that it infects. Specifically, the complaint alleges that a person can touch a surface, an infected surface, and later transmit the virus to either themselves, such as the specific reference is if they touch their face or their eye and become infected, or they can bring it to other properties. And the specific reference in the complaint is it can travel on people's shoes. The court must accept those allegations as true. Repairs are required when COVID-19 is present on a property, and that takes the form of deep cleaning. We all know that that is required when COVID-19 is infected, and that is, I think, referenced in the executive orders that were referred to in the complaint and attached to the complaint. So even under the defendant's definition, COVID-19 causes direct physical loss to property where it is present. This is not a situation where there is a pure economic loss. This is not a hypothetical situation. This is a situation akin to smoke, or akin to take a more extreme and a more drastic and a more dramatic example, let's say a car crashes into the side of a building, the building does not need to fall down. The building does not need to collapse. Cosmetic damage that would require repairs would be a covered occurrence. There is a grant of coverage here. Your Honor, our case is different from the Gavrilides case that this court previously considered. It is different, quite frankly, than the cases, the numerous federal court cases that were cited by the defendant. This case needs to stand and fall on the merits of the complaint and of the individual policy that's involved here. And I will just say that Couch certainly is a persuasive treatise for the court to follow, but it cannot be followed in this case because Couch takes the view that microscopic things cannot be physical loss, that there is physical alteration that is required, structural alteration. That's not the case under this policy. This policy contains an exclusion for bacteria. And so if a microscopic object could not be covered, there would be no need for that exclusion for bacteria. The court can't follow Couch because that reading violates Michigan rules of contract construction. It would render the bacteria exclusion nugatory. So you can't follow Couch in this case. I will note the bacteria exclusion has to be applied according to its terms. COVID-19 is not a bacteria, it's a virus. There is no virus exclusion in this policy. Your Honor, for those reasons, our case is different. I think that I would also like to discuss that the government acts exclusion that the defendant relies upon is not dispositive in this matter, including most importantly with respect to the civil authority coverage. As we discussed in our brief, that language is subject to the other provisions of the policy, most notably the civil authority coverage, which provides that there is coverage when a government act or a government decision is made. At best, the defendant's argument would create an ambiguity, and that would create a question of fact. I did submit, the defendant made reference to Salon XL, a decision from Judge Cox out of the Eastern District from, I believe, Thursday of last week. That has phrasing identical to the phrasing in the civil authority coverage, and did, contrary to the defendant's suggestion that it contained no analysis, did contain an analysis that found that there was direct physical loss caused by COVID-19, caused by a virus, and that at best that there's an ambiguity in the policy. Now, you can't follow it exactly because the facts of the case are different. That policy had a virus exclusion. That policy had a no consequential loss exclusion. Those exclusions are not present here. And so what Judge Cox found was that under a business income coverage, there is direct physical loss, and that the first step in the analysis, is there a grant of coverage, was satisfied. He then went to apply an exclusion, which is not present here, and he held that there's no business income coverage under that exclusion. Adopting that analysis, you would need to find, and I urge you to find, that there is physical loss, or direct physical loss here. But then when you go to the next step, there's no exclusion, there's no virus exclusion. And so I do think that case is highly persuasive. I'm not so interested in what the national cases or what the national trend state, because you have to apply Michigan rules of contract construction, and you need to apply the policy in this case, and you need to apply it against the facts alleged in this complaint. So the other cases are not so relevant. You are forbidden by the Court of Appeals and the Supreme Court from construing the policy. If we have an unambiguous policy, no further construction is necessary. You just apply the dictionary definitions, which is what we do in our brief. And when we do that, we find clearly COVID-19 has physical existence. Clearly, it infects the surface and contaminates the surface. And so contamination is a structural alteration that requires repairs. It doesn't infect everything. It doesn't go down to the core, but it changes the surface of the property, and it takes a satisfactory surface that can be used for an intended purpose and renders it an unsatisfactory property and an unsatisfactory surface that can no longer be used for its intended purpose. And so because of that, there is physical loss here. I would say finally, to the extent that you hold against us in the business income or the extra expense coverages, there's clearly coverage under the civil authority provision because there was damage to the property. And let me be specific here because I've misphrased that. There was damage to other properties. The issue is not whether there was COVID-19 at plaintiff's property with respect to the civil authority coverage. The issue was whether there is COVID-19 at any property and whether at any property it's causing physical damage. Clearly it causes physical damage. Clearly it affects the surface of the property. And then the next inquiry is, did the presence of COVID-19 cause an act by the civil authority to prohibit access to the plaintiff's property? That clearly happened. And any suggestion that that's not alleged in the complaint, I strongly disagree with. But if we have not alleged that to this court's satisfaction, I would request an opportunity to amend the complaint because clearly that is what happened. Discovery will yield whether there were asymptomatic individuals that entered the massage salon, the salon, the spa, whether there were non-symptomatic employees that worked there that were later diagnosed with COVID. Those are questions for discovery. For now, for this motion, a state of claim motion, we've alleged that there was that COVID-19 was likely to be there, was more likely than not to be there. That's sufficient to state a claim. This motion should be denied, Your Honor. We have stated a valid claim.
Okay, thank you. And Ms. Fatma, I'll give you just a brief rebuttal. You did go a little long on your main argument, so just a brief one.
Yes, Your Honor, thank you. Your Honor, plaintiff notes that there is some physical damage to the massage parlor because it can be transferred in or brought into the massage parlor's business by people, and therefore that would require direct or deep cleaning. I again note that the plaintiff's complaint is devoid of any allegations that COVID-19 was actually confirmed in the salon, whether by an employee, a customer, or a visitor. So under those circumstances, there can be no requirement that deep cleaning occurred as a result of the confirmed presence of COVID-19. Other courts have also addressed whether a requirement that deep cleaning occur constitutes a physical loss. And those courts that have addressed it have held that is nothing more than a purely economic claim. As to the acts or decisions, as we noted on a footnote to a reply, Your Honor, page 2, footnote 4, the acts or decisions exclusion bars coverage where the loss complained of is solely a result of the acts or decisions without physical damage. If acts or decisions result in a covered loss, then the ensuing covered loss is covered. So, for example, acts or decisions would not bar coverage where an arsonist decides to burn down a property. The act or decision of the arsonist to burn down the property might be an act or decision, but under those circumstances, the property damage itself would still be covered. So any tension or alleged ambiguity in terms of the exclusion is resolved by recognizing if a peril is not otherwise excluded in suit, coverage is provided. It is our position, Your Honor, that any amendments to the complaint as just now raised would be futile because, again, there has been no allegations that it was ever linked specifically to this property. And again, the civil authority orders that were not issued, nor do they reference property damage, but rather to protect Michigan residents. Thank you, Your Honor.
All right, thank you. Well, there are 3 areas of the policy that have language that is pertinent to this coverage dispute. And I'm talking about first section 1, perils and exclusions. It says this policy insures against direct physical loss. Also in section 1, loss of business income. It covers loss of business income caused by the perils insured against damaging or destroying buildings or business personal property. And then also under loss of business income, it provides that that extends to the length of time required to rebuild, repair, or replace the part of the property that's been damaged or destroyed. The plaintiff has argued and has taken three words, direct, physical, and loss, which do appear in the policy, as I've just indicated, but the plaintiff separates them out from each other to argue that there is coverage in this case. But these aren't separate words unrelated to each other in the policy. Direct modifies loss, physical modifies loss. So plaintiff, at least in the briefing, made an argument that a virus has material existence and therefore it's physical. That argument is unavailing because it's the loss that must be physical and not the virus itself. Likewise, the plaintiff's argument that being unable to use a room in your house or your office would be a loss ignores the fact again that the loss must be physical. Now, the plaintiff does maintain that having no people in your business is a physical loss, but I can't stretch the plain meaning of physical loss that far. I'm also required to read all the pertinent sections of the policy, and plaintiff's interpretation flies in the face of this other language that I've already referenced, and that is the language about damaging and destroying buildings or business personal property in Section 1, loss of business income, as well as the time limitation on business income loss, which only extends to the length of time required to rebuild, repair, or replace the part of the property that's been damaged or destroyed. So the policy language directly contradicts the notion that not having people in your business is a direct physical loss. That was the same interpretation applied to direct physical loss that the federal court had in the Universal Image Productions case. The analysis that the federal court made in that case was that direct, and the plaintiff acknowledged this in the briefing, but it's what the court said. Direct actually refers to causation, and physical loss requires something that alters the structural integrity of the property. Plaintiff does address the Universal case and makes two arguments about it in the briefing that I want to address together. First, the plaintiff says that it has at least stated a claim, and that Universal did not hold that the plaintiff had failed to state a claim. And second, the plaintiff says that the problem in Universal was a factual one. That is, that the plaintiff's own expert couldn't say that the premises was uninhabitable. Well, the Universal court actually decided two issues: whether the loss was direct, that is the causation issue, and whether the loss was physical. In finding that the loss was not physical, the court looked to the language of the policy and applied the rules of contract construction, where words that are clear and unambiguous are enforced using their plain and commonly understood meaning. And that aspect of the court's decision, which is similar to what we have here, is what we do in state court in a C8 motion. And that's what this motion is, a C8 motion, looking only to the language of the insurance policy. When the Universal court considered the plaintiff's expert's opinion, it was considering whether the loss was direct, and that is whether the odor in Universal caused the premises to be uninhabitable. And that aspect of the court's ruling was like a C10 treatment under state law because it considered deposition testimony. But this case doesn't call into question causation, not the direct language. This case calls into question the physical loss language. This is not a C10 motion. This is a C8 motion. A C8 motion challenges the legal sufficiency of the complaint. All well-pled allegations in the complaint are taken as true, and summary disposition is only granted if the claim is so clearly unenforceable as a matter of law that no factual development could possibly justify recovery. In a contract case, which this is, the contract upon which the claim is based is considered, just as in the Universal case, And if it is clear and unambiguous, it is enforced just as in the universal case. So I reject the plaintiff's argument that universal is different in those respects, because the issue in universal that is similar to the issue here is the C8 issue, which is the language of the policy and looking only at the well-pled facts and the well-pled allegations in the complaint and the language of the insurance policy. The complaint in this case makes plenty of allegations about the virus, but the only thing it can and does allege about the virus's presence on the insured property comes in paragraph 40, where it says, quote, "It is likely customers, employees, and/or other visitors to the insured property over the months prior to, during, and after the government shutdown were infected with the coronavirus and thereby caused physical loss and damage to the property," end quote. The plaintiff has really stressed today that the court must take these allegations as true, but this is not a well-pled allegation that the court must take as true. This is pure speculation. There's nothing to allege that the virus was actually present at the premises. So the court does not have to take this allegation as true, because this allegation, again, is nothing but mere speculation. Not only does the insurance policy clearly and unambiguously require a direct physical loss in the form of damage or destruction of the insured premises, but even if the coronavirus could be such a loss, the complaint does not and cannot at this point allege that the coronavirus was ever present on the premises to cause a shutdown. Now, the plaintiff has asked to amend the complaint. There was no proposed amended complaint, even though the defendant raised this issue in writing that was submitted. The court rules require that it be in writing. But nevertheless, considering that request, I would call it futile, because even if somehow the plaintiff could allege that someone was asymptomatic in the premises during this time before it was shut down, that does not establish and cannot establish that the coronavirus was actually present in the physical premises of the business, only that a person was asymptomatic. And you still can't get around the language of the insurance policy that requires direct physical loss. So the proposed amendment, such as it is, not in writing, but nevertheless, the court finds would be futile. So one other point the plaintiff makes, and the plaintiff says that it's that allegation in the complaint about the coronavirus being present that makes this case different from Gavrilidis, which is the case the court previously ruled on. And again, I would just say it does not, because essentially if you take out the pure speculation in the complaint, this case is no different than that other case, in that there's no allegation that coronavirus was ever present in the property, and the language of the insurance policy would not cover under those circumstances in any event. This is also the reason why this court finds the cases cited by the plaintiff under this issue to be inapplicable. There are cases from other states, federal cases, I believe they were, if I remember correctly, where there was actually an actual physical impact to the business or the property. So General Mills versus Gold Medal Insurance from Minnesota, where cereal oats were actually infested by an unapproved pesticide, or Stack Metallurgical Services versus Travelers Indemnity Company, Connecticut case where a hammer disintegrated inside the insured's furnace. Farmers Insurance Company from Oregon, where an odor from cooking methamphetamine infiltrated a home. Oregon Shakespeare Festival Association, where smoke caused an unhealthy level of particulates, causing evacuation of an indoor theater. So all of those are not applicable in this case, where the only thing the plaintiff can allege at best is that the coronavirus was likely present, but cannot say that it was present. The complaint does not allege and cannot allege that coronavirus actually infiltrated the plaintiff business, causing a shutdown. What the complaint really does allege is that the business was shut down because of the executive order, which calls into question two provisions of the policy: the acts or decisions exclusion and the civil authority coverage. The acts or decisions exclusion provides, quote, "We will not be liable for loss caused by acts or decisions of any person, group, organization, or governmental body. However, if a peril not otherwise excluded ensues, we will pay for the loss caused by the ensuing peril," end quote. Perils insured against is defined with respect to loss of business income as the perils defined and limited by the policy. So that takes us right back to the requirement of direct physical loss. There has to be an insured peril that results from an act of a governmental body. There is no direct physical loss here that resulted from the shutdown order. I want to be clear in this respect, and I regret not being clear in the previous Gavrilides case. It is without a doubt that the plaintiff, like so many other small businesses, suffered a very regrettable loss. And I'm not making light of that or denying the loss. And it's beyond unfortunate. It's devastating. But the loss was not insured against per the clear and unambiguous language of the policy. The other argument that the plaintiff makes is that the civil authority coverage provides an independent basis for coverage in this case. That provision is an extension of coverage for loss of business income, and it reads as follows. "We will pay for the actual loss of business income you sustain and necessary extra expense caused by action of civil authority that prohibits access to the premises described in the declarations due to direct physical loss of or damage to property other than at the premises described in the declarations, caused by or resulting from a peril not otherwise excluded under this policy." So what that says is that direct physical loss to a property other than the insured property that requires a civil authority to prohibit access to the insured property may trigger lost income coverage to the insured business. That didn't happen here, and that's not alleged in the complaint to have happened here. My reading of that provision is verified by the federal court's treatment of similar provisions, and those are cited by the defendant in footnote 3 of its brief. So, example, if a vehicle ran into a building near the insured building or the insured business, and a civil authority said the building is in danger of collapsing, so you have to close down your insured business, that is a situation that could potentially provide coverage under the civil authority provision. But even in this case, if another business had the virus present, that does not provide coverage under this civil authority coverage provision, because there still has to be a direct physical loss to the business that is not the insured business. So again, with the coronavirus not constituting a direct physical loss, the civil authority coverage cannot apply by the terms of that coverage. The Michigan cases cited by the plaintiff also do not change that conclusion. And those are the Michigan cases that deal with, well, they're all three from the era of the 1968 riots in Detroit. First, none of the three is binding because they come before November 1st, 1990. So even though they are published decisions per the court rules, they are not binding precedent because of their earlier date. One of them has no policy language in it at all. So no comparison whatsoever can be made to the policy in this case. And the other two have policy language quoted that differs from the policy language here. So it is not only not binding, but those cases are not persuasive either. There are other cases cited by the plaintiff, not just with respect to the civil authority coverage argument, but just the cases in general pertaining to the interpretation of direct physical loss. But those are all federal cases. They're certainly not binding. I do not find them persuasive. I think that what is persuasive and compelling here is going back to the exact language of the policy and the fact that it calls for direct physical loss and provides that loss of business income is covered for the length of time required to rebuild, repair, or replace the part of the property that's been damaged or destroyed, and refers to loss of business income caused by the perils insured against damaging or destroying buildings. So for all of those reasons, those cases are not persuasive, and they either have different policy language or they're simply not persuasive with respect to the policy language that we have here. There are other federal cases, a couple of which I've already mentioned, that are persuasive with respect to the policy language that is at issue here. There's another argument that I'll throw under the miscellaneous argument category that the plaintiff makes that seems to be based on the fact that this case has no virus exclusion. But coverage isn't determined by looking at what exclusions the policy does not have. Coverage is determined by looking at the coverage language in the policy and then turning to exclusions to see if any exclusions cover the situation. And I've already addressed that here. But to the extent that the plaintiff is arguing that somehow there's coverage by virtue of no virus exclusion, that's not a proper interpretation of insurance policies. So for all of those reasons, I am granting the defendant's motion for summary disposition under C8. And Ms. Fatma, that would be your order to prepare. And you can just say under C8 for the reasons stated on the record.
Thank you, Your Honor. We will submit that under the 7-day rule.
Yes, and
Thank
thank you, Your Honor. I know that my client will appreciate your expression of sympathy for this, what is truly an unfortunate situation that's outside of everybody's control here. So.
It is. I truly mean that. And some of these small businesses that are suffering, frankly, are some of my favorite small businesses in town. But that's not how I have to decide cases, unfortunately.
Unfortunately for me, Your Honor, yes. Thank you. Thank you so much.